Good afternoon. Good afternoon in France and in Malta. Today we have a match, a day 2 match, so second match for two teams in the group E. So the two teams are Paris 1 Pantheon-Sorbonne University and the University of Malta. They will be debating on topics they received 7 days ago. I give the floor to Ms. Urbanova. Yes? Yes, you are back. You can have the floor, Ms. Urbanova.
Thank you very much. Apologies for technical disconnect. So welcome to the two teams today, and of course to all your supporters and also the three judges that will be viewing this match, or perhaps already are. Today's debate topic is whether or not the right to life obliges states to prevent foreseeable long-term environmental harm that threatens the survival of future generations. The two teams have received this topic 7 days in advance, and in a short while we'll find out which team will represent which side. But before we get to that part, now passing the floor for the introductions to the teams, starting with the University of Malta's Ms. Aguilina.
Hello, good afternoon, everybody. My name is Cara. I'm a third-year student studying Bachelor's of Laws at the University of Malta. I'm very happy to be here, and I'm looking forward to a fruitful debate.
Thank you.
Hi, I'm Michael. I'm a fourth-year law student at the University of Malta as well. I've been debating for quite a while now, and now I'm enjoying this more legal international law debating style as well, and I'm looking forward to a fruitful debate as well. Thank you.
Thank you. Welcome. And now to Paris 1 Pantheon-Sorbonne University, perhaps starting with Ms. Castellani.
Hi everyone, I'm a fourth-year law student in Paris Pantheon-Sorbonne in international business law, and I'm looking forward for this debate with you all.
Hello, I'm Alice. I'm also a first-year student in international business law at Paris Pantheon-Sorbonne University, and I really like the subject of this debate, so I'm really looking forward.
Well, thank you, everyone, and once again, welcome. Also, we would like to give the big thank you for the supporters of the two teams. I believe for University of Malta, your coaches are Dr. Grima and Professor Gretsch, as well as Dr. Komadini Katja. And of course, I won't keep you waiting much longer. In a short while, you should be able to see the wheel for the allocation of two positions. I will just ask for audio confirmation for when you do. If you can see the wheel.
It is charging now. I see the wheel on my side. Yeah.
All right, thank you for confirmation. So as the teams you are already aware, there are two possibilities for each team, for and against. So for today, it is the University of Malta's debate team that will argue for the against position, and thus Paris 1 Pantheon-Sorbonne University will argue in favor of the statement that the right to life obliges states to prevent foreseeable long-term environmental harm that threatens the survival of future generations. And the team of University of Malta will argue against this motion, thus that the right to life does not oblige states to prevent such harm. You will now have 5 minutes to finalize your preparations. Feel free to close your cameras and mics. Thank you, everyone. Your time for final preparation has now passed. We'll proceed by hearing the opening statements, starting with the position in favor of the Pantheon-Sorbonne. You have 4 minutes.
Thank you very much. I will start in 3, 2, 1, go. So, honorable judges, dear opponent, from many movies in Hollywood, we have long imagined dystopias where pollution silently destroys life. But today it's not a fiction when water is toxic and when land is irreversibly damaged. A polluted life is a diminished life and even a lost life. So the right to life is no longer just the right not to be killed. It's the right of having and living a sustainable life. We define so the right to life as a binding norm of international law enriched in Article 6 of the ICCPR and Article 2 of the European Convention of Human Rights. Foreseeable long-term environment harms refers to scientifically established cumulative and potentially irreversible damage, and future generation refers not to abstract entities. This is an intertemporal extension of today humanity, those whose survival depends on today solutions and today actions. Since the Stockholm Conferences in 1972, the international community has acknowledged the environmental degradation threaten human existence itself. Courts no longer treat environmental harm as a marginal issue. They recognize that climate change and ecological collapse constitute foreseeable risk to human survival. The science is clear. The harm is long-term. The question is therefore legal. Does the right to live oblige states to prevent it? And today we are witnessing a profound evolution. The right to life, once confined, protection against immediate violence, is increasingly interpreted as protecting the conditions that make life sustainable. Court across jurisdictions has begun to understand life as ecological and interdependent. So even some courts has even recognize rivers and animals some right to live, not because they fall under the Article 2 and 6, but because law is progressively acknowledging that life is rational and must be protected. So right to life is not even anthropomorphic anymore. This is concerned, it is about living entity. So this debate is not about transforming judge into climate policymakers. This is about legal coherences. If the right to life is the foundation of all rights, and in some way we can say this is, then it cannot remain indifferent to foreseeable long-term environmental harm that threaten the survival of future generation. And this is fundamental to understand this part. We contend that when environmental harm poses a foreseeable long-term harm that threaten human survival, the right to life necessarily oblige states to act. And to demonstrate this, to demonstrate that the right to life is also a right to a sustainable life, we will show how the structure of the right to life already contains structural obligation to our environmental protection. And in the second matter, we would like to assert that when there is an environmental harm, this is about cumulative and intergenerational future, not about today. So, I'm done.
Thank you very much. I will now hear the opening statements for the against position by debaters of University of Malta. You have 4 minutes. You are muted, please. Thank you.
Am I audible and visible?
Yes, you are.
I will start in 3, 2, 1. Honourable judges, esteemed opponents, good afternoon. The motion claims that the right to life obliges states to prevent foreseeable long-term environmental harm that threatens the survival of future generations. We do not dispute that climate change is real, that its consequences are serious, or that states have environmental obligations. What we dispute is that the right to life specifically generates the generalized, enforceable obligation of the scope and character that the motion describes. The motion merges three things that international law keeps structurally separate: the existence of environmental threats, the content of the right to life, and the enforceability of intergenerational obligations. Our case stresses on three contentions. First, the right to life protects against real and immediate threats to identifiable persons, not diffuse long-term environmental risks. The positive obligation under Article 2 of the Convention, the European Convention of Human Rights, established in Osman versus the UK, arises only where authorities knew or ought to have known of a real and immediate risk to the life of an identified individual. Foreseeable is not the same as real and immediate. Long-term climate projections, however scientifically robust, identify aggregate probabilistic risks to populations over decades. They do not meet the threshold the right to life has historically required. Critically, in Klima Senioren versus Switzerland, the European Court of Human Rights' own landmark climate judgment, the Grand Chamber deliberately anchored its finding in Article 8, the right to private life, not Article 2, the right to life. This was not accidental. Article 8 carries a lower threshold and wider margin of appreciation. If the European Court of Human Rights itself, in its first ever climate ruling, declined to ground the obligation in the right to life, this is powerful evidence that Article 2 does not bear the weight the motion places upon it. Environmental harm affecting health, well-being, and living conditions is serious, but it is an Article 8 concern, not an Article 2 concern. This restraint is consistent across fora. In Hatton versus UK, the court rejected an Article 2 attempt to reframe long-term environmental nuisance as a right to life violation, emphasizing institutional limits in policy balancing. Likewise, the Human Rights Committee in THIULDT versus New Zealand and Daniel Billy and others versus Australia found no Article 6 violation on the facts, underscoring the high threshold for life-based claims. Second, climate harm presents a structural mismatch with human rights adjudication. Human rights law is designed for identifiable victims and conduct attributable to a specific state. Climate harm is cumulative, cross-border, multi-actor, and temporally diffuse. In Duarte Agostino versus Portugal and 32 other states, the Grand Chamber unanimously declared the application inadmissible, emphasizing limits of jurisdiction, causation, attribution, and refusing to extend Article 2 into a general duty to protect future generations from climate change. This is the Grand Chamber explicitly declining to do what the motion asks us to accept. Third, the motion claims an obligation that binding law has not established. The proposition's strongest authorities, being the ICJ, ITLAWs, the Inter-American Court of Human Rights, advisory opinions, are not binding. Advisory opinions provide normative guidance. They do not create enforceable obligations. The motion uses the word obliges. An obligation in law is binding. If the strongest evidence for this obligation consists of non-binding opinions, the obligation has not yet crystallized into law. Meanwhile, 196 parties to the Paris Agreement deliberately chose a non-judicially enforceable pledge and review architecture precisely because states insisted on sovereign discretion over climate policy. We urge you to reject this motion.
Thank you. We have heard the opening statements. Now proceeding to hear the rebuttals. Paris and Pantheon-Sorbonne, you have 2 minutes for your first.
Thank you. I will start now. Dear judges and opponents, the right to life has evolved into a structural obligation to safeguard the condition of viable life. And I have to contradict what has just been said, because indeed, the right to life was not originally conceived as an environmental law norm. Under Article 2 of the European Convention on Human Rights and Article C of the ICCPR, it was first understood as a defensive shield, a prohibition against arbitrary killing, a limit on the use of force, a protection against immediate lethal danger, but that has changed. The text did not freeze the right in that narrow conception. In Onardili versus Turkey, the European Court did not simply condemn the tragic explosion of a landfill that killed 9 people. It condemned the state's failure to regulate a known and foreseeable risk. It held that when authorities are aware of a danger to life, Article 2 obliges them to establish a regulatory framework capable of preventing that harm. That is the legal turning point. The right to life is violated not only by killing, but by allowing a forcible lethal risk to persist without governance. And this is precisely why climate change falls within the right to life. Climate change is not speculative, it is scientifically established, it is cumulative, and it is partially irreversible. This reasoning was made explicit in Agenda in 2019, when the Dutch Supreme Court held that climate inaction can breach Article 2 and 8 of the ECHR, because states have positive obligation to protect individuals against serious and forcible threats to life. It ordered emissions reduction not as political preference, but as prevention required by fundamental rights. Because a right that protects life must also protect the conditions that make life sustainable. Thank you.
Thank you. University of Malta, you have 2 minutes for your first against rebuttal.
Thank you. Am I audible and visible?
You are.
So I will start in 3, 2, 1. The proponent here has used the exact word for what this argument has all been about: speculation. So far, all we've heard are claims of obliges, not originally imposed, at first understood. This is not the case. Legally, the right to life does not extend to environment as an independent protected interest. Its function to protect individuals against arbitrary deprivation of life do not operate as a general environmental guarantee. International jurisprudence consistently treats environmental protection as indirect and conditional, requiring a demonstration, concrete and immediate risk to identifiable individuals. Where such a threshold is met, courts refuse to subsume environmental harm into the right of life, emphasizing that doing so would collapse distinct legal regimes and bypass the specific treaties, standards, and consent-based frameworks governing environmental law currently. Recognition of this interaction is not the same as legal extension, and this is what our whole argument is focused on, and the law has been careful to preserve this distinction. Our proponent, their reliance on long-term harm, actually weakens their case, because international human rights law is not designed to operate on open-ended timelines. The right to life is triggered by concrete and immediate risks, not by harms projected decades into the future on the basis of evolving scientific assumptions. Courts have recognized this limitation before as well. In Armada Bako Andolan versus Union of India, the Supreme Court of India explicitly refused to halt a major development project despite acknowledging the long-term and environmental intergenerational impacts, holding that speculative future harm could not override present policy choices or even establish a violation of the right to life. Once harm is framed as long-term, it becomes legally indeterminate. There is no clear threshold for when it begins, or how certain it must be, or how far into the future legal responsibility extends. Law cannot impose on binding obligations on the basis of predictions that are inherently irreversible and temporarily uncertain. Thank you.
Thank you. Now to hear the second rebuttal for the in favor position, Pantheon-Sorbonne University, you have 2 minutes.
Thank you very much. I will continue in 3, 2, 1. Dear opponent, the opposition claimed that the right to life does not extend to environment, and we would like to say our disagreement. The right to life is not just about not being killed. The right to life, in his coherence as a legal article, means to protect life. This is about the idea behind the text. The law is always about interpretation of the idea that was used to write the text. The text was written in the idea to protect life in all his form. And today, when we face this kind of environmental long-term harm, we the court understood that we just need to protect life beyond the fact to not immediately be killed. We need to protect it in his viable innocence, because a polluted life, as I said, is a lost life. So in the idea of the text, the Article 2 of the European Convention of Human Rights does apply to the protection of environmental of people. This is fundamental to understand. Also, the opposition claimed that the court is careful in the use of human rights. On this aspect, we need to agree. The court has for a long time been careful on the use of human rights, the right to life, to not open the Pandora box. This is true, but this is not true today anymore. Facing the urgency, in the advisory opinion OC 2317 of the Inter-American Court of Human Rights explicitly held that environmental degradation can affect the right of life, and that states have prevented obligations even when harm may impact future generations. And I will just end on the point where opponent claim that future generation does not have a right. They are concerned by today's harms, so they are concerned. Thank you very much.
Thank you very much. Now to hear the second rebuttal for the against position, University of Malta, you have 2 minutes.
Am I audible and visible?
You are.
I will begin in 3, 2, 1. The proposition cited the case Urgenda as binding domestic judgment establishing this obligation, but may we remind the proposition that domestic judgments bind only the state concerned and do not create rules of general international law. Urgenda was a Dutch Supreme Court decision applying Articles 2 and 8 of the European Convention of Human Rights to the specific Dutch emissions context. There was also another case of Neubauer, a German Federal Constitutional Court decision applying Article 2, Sub-Article 2 of Basic Law of Germany, a provision specifically addressing intergenerational environmental responsibility. And so neither judgment can be generalized into a universal obligation under the right to life. The opposition also mentions the idea that the obligation is focused on present conduct. So if it is focused on present conduct, then it must be enforced by present persons. Present persons must demonstrate a present violation of a present right. But the motion's harm by its own terms as long-term and directed at future generations, the proposition cannot therefore simultaneously claim that the harm is future but the violation is present. Either the harm is currently occurring to current persons, in which case existing human rights mechanisms already apply without the motion's expansion, or the harm is future and speculative, in which case the right to life's real and immediate risk threshold is not met. And to conclude, the opposition also mentioned other cases, but we have to keep in mind that the main jurisprudence, for example, Clima Seniorin that I had mentioned before, grounded its finding in Article 8, not the right to life. In Duarte Agostino, that was admissible, and there was a refusal to extend the right to life to long-term cross-border climate harm. So therefore, the motion against stands. Thank you.
Thank you. We'll now hear the concluding statements, starting with Paris and Pantheon-Sorbonne University. You have 2 minutes.
Thank you. I will start now. This debate now comes down to one fundamental question: is the right to life a static shield against immediate violence, or a dynamic obligation to prevent forcible existential risk? And we demonstrated two things. First, under Article 2 of the ECHR and Article C of the ICCPR, the right to life has evolved from a reactive prohibition into a structural duty of risk governance. Secondly, we prove that the right to life is inherently intertemporal, protecting life today while allowing its predictable long-term destructions is not protection, it is postponement. And the opposition says that there is no obligation because future generations do not exist yet, but the causal decisions are made today. the risk is created today. Therefore, the obligation arises today. And they talked about human rights law, but human rights law protects against foreseeable risks, not only against deaths that have already occurred. This was precisely the reasoning on the German Federal Constitutional Court in its 2021 climate decision, which held that present emission policies unconstitutionally restricted the freedom of future generations. The violations stem from today's legislative choices. And finally, the claim that there is no binding law overlook legal evolution. More than 150 constitutions now recognize environmental protection, and several constitutional courts have issued binding climate change judgments. Normative guidance is crystallized into obligations. They do create international customs that is binding. The right to life has been used carefully, but still has been used. And if the purpose of fundamental rights is to safeguard human survival, then the right to life cannot and do not ignore systemic environmental collapse. At the end of this debate, one principle stands clear. The right to life is not merely the right not to be killed, it is a right to exist within a viable ecological horizon. Thank you.
Thank you. We'll now hear the concluding statements for Deacon's position by University of Malta. 2 minutes.
Thank you. Am I audible and visible?
You are.
Yes, I will start in 3, 2, 1. Judges, this debate is not about whether climate change is dangerous. It is about whether the right to life creates the specific, binding, enforceable obligation the motion describes. The evidence says it does not. The proponent fails to understand that the fact remains that the right to life is out of scope in this debate. Guidance we accept. It is advice. However, it is not legally binding. First, laws build on binding obligations, not aspiration, as the proponent has suggested. Much of what the proposition relies on, advisory opinions, general comments, and progressive judicial language, is explicitly non-binding. Advisory opinions do not create legal duties. They persuade, they guide, but they do not compel. To treat them as binding would collapse the distinction between law and policy and undermine the principal state consent at the heart of international law. Second, the right to life has limits. The courts have consistently required an immediate and attributional risk. Long-term environmental harm, global, cumulative, and international level do not fit the framework. When this argument was tested in cases like Duarte Agostinho, it was rejected at the admissibility stage, precisely because climate harm does not meet the legal threshold of causation and jurisdiction. Third and finally, even domestic courts cited by the proposition are exceptional, not generalizable. For Henda, Naibara, they rest on unique constitutional structures and domestic legislation. They do not translate into universal international obligations. By contrast, binding judgments show judicial restraint, refusing to convert the right to life into a substantive prohibition, and development long environmental risks. Human rights derive their force from specificity. A right that covers everything protects nothing. In short, concern is not an obligation, consensus is not consent, and urgency is not law. The right to life protects against concrete and immediate threats, not speculative long-term environmental futures. For these reasons, we urge you to reject this motion. Thank you.
Thank you. Thank you to both teams for your concluding statements. You can all now relax. You are no longer graded after this part. As always, you will have a bit of time before you hear back from us with the scores from the judges. Judges themselves have 2 working days to review your match and spin the scores. But already now we can do a short exchange on today's match. So I would like to invite you to take the time a bit to reflect on how was the debate, how was the research for you, the topic, and perhaps if you had familiar arguments from the opposing team. Starting with Paris and Pantheon-Sorbonne, Ms. Pitel.
Well, thank you. Well, we really liked the debate, and I did not study environmental law, but I know that Laure studied it, so she kind of explained a little bit about the right to life to me and things like that. So it was pretty interesting to discover like this whole part of law that I didn't know, and to look at like real cases, but also like put it with like what is actually happening in the world right now. So I really liked the debate, and working on both sides, whether it's like for or against, was very interesting.
Thank you. From Malta, Mr. Gutt, how was it for you? The same question.
I think the research stage was very interesting. This was a super interesting topic, and I think it resonated a lot with me personally because I love environmental law. I've taken several amount of units on it as well, and I think Cara has too. So I think we prepared well in advance. I mean, the proponent had many interesting topics as well. They had a lot of good points. It's something that we had encountered in our research as well. It was something nice to see how it was well debated as well. So it was a pleasure, I think, to debate with Pantheon-Sorbonne as well.
Thank you. Ms. Castellani, how was the debate today for you?
I was really happy with the debates. First was I really enjoyed it, and also the subject, I absolutely loved it. I studied environmental law on the first semester. That was very fortunate, and also that's also the reason why I started to study law 4 years ago. So this kind of topics really resonate to me, and I was happy to defend the pro. This resonated a bit more with myself, but the opposition has really interesting point, and it was a very interesting match. So I'm really happy.
Thank you very much. Ms. Aquilina, how was the debate for you?
For myself, I'll be reiterating the points that colleagues have mentioned. Very interesting topic. Also, to see the intersectionality of different branches of international law was great. To see international environmental, human rights law, and to see how they intersect and intermingle, and also to research both the affirmative case and the case in opposition, and to see how to create those sense of having an idea, but then in your mind also creating an instant rebuttal as to how you would dismantle that argument, and then vice versa. So that's also a very interesting process with the issue spotting, and it was a very fruitful debate. I thank colleagues at Sorbonne for their points, and looking forward to the next one.
Very well, thank you very much. We're happy that you have enjoyed the debate, and we look forward to seeing your teams in the day 3. Of course, we do encourage networking and exchange throughout the competition. And for that part of today's session, passing the floor to Professor Lange to take over.
Yes, well done for this second match. That was really, really interesting to see you debating on that topic, particularly. And now, I would like to ask 2 questions to both teams. And the first question would be, have you watched some other match this year, the previous year? What really, let's say, challenged you, or what was impressing for you from other universities, from other teams? So that is for the first question. So it means previous match or match happening this year. And the second question as well is, which type of skill do you think you develop the most, or you are developing the most at this moment during the competition? So it could be a legal reasoning or some others. So I would like to start with the team from Malta. So who wants to start in Malta?
For myself, I think one of the skills that we've been really developing and refining has been the issue spotting, and also the how to operate in the strict time constraints that are given. And what I also admire from previous debaters, having watched previous debates, is their ability, and now our ability, to process information so quickly and be able to create well-developed rebuttals, and to transform what you would have researched and read and gone through into a short and to the point, concise and strong argument and rebuttal. So I think that's a skill that I'm really appreciating developing, and I'm looking forward to continuing refining that skill.
Thank you. And Mr. Gatt, have you seen other teams debating as well?
I think the most notable debate, I watched the opener for sure. It was a really good debate between 2 very good teams as well. I really enjoyed their professionality and all of it, and I think it inspired a lot of teams that followed that debate as well, because a lot of us, I saw their language as well, and it was very up to the debating standards that I've seen abroad as well. So it really heightened the level of this debate, I would say, and I think it's something that I think all of us drew a bit of inspiration from. And then in terms of skills maybe that I've gained throughout this debate as well, I think Cara said it perfectly as well. it's mostly the rebuttal aspect of it all, being able to formulate such quick on-the-spot thinking and counteract what the opponent has said, especially when it's something that maybe you resonate with, and taking on a bit of a different, taking on different shoes as well. So it's something that's very interesting and something I look forward to continue developing throughout this tournament as well.
Thank you. Same question for the team from Paris. So have you watched some other match, and what are the skills that you are developing the most?
I did watch all the matches from last year and this year also, to follow a little bit what was going on. And I think I will say exactly the same thing, the rebuttal. I think, at least for me also, that's the most challenging. And I wanted to see how make it looks fluid, make it look like I'm not looking for my words all the time. So I think that's really what is the most interesting to see when you see other people debating. And also, so that's one quality that we develop, I think, and also the capacity of having an opinion on both sides, pro and cons. I think it's really human when we see the subject that immediately say, oh, I'm for or I'm against. And we are forced during the preparation to question ourselves, which is the pro, which are the pro, which are the cons. So this is a really interesting intellectual exercise. And maybe also English, it's not my mother tongue. So it's always a bit challenging to debate actually in English.
Thank you. And Miss Peter?
Yes, well, I did watch some of the debates from last year and this year, and really to understand, I think, first, like the structure, how it was going to happen before my first match, and then after how people construct their arguments and rebuttals, etc. So it was very interesting to watch this. And for the skills, I think I would pretty much summarize what everybody said, but first, debating in English can be quite challenging, but also to work on a team, I think it was pretty interesting to find together arguments that we agreed on, and to look at if they were really convincing or not. Also the fact that we had to, as everybody said, but we had to prepare the pros and cons was pretty challenging, especially when we're not in agreement with the pro or the con. And and also respecting time was quite hard, especially when you like to talk a lot. So yeah, but that's a challenge, and that's nice to practice.
Thank you very much. So we encourage you again to watch the match from other teams. For example, the one in your group, the group E, for the two other universities. So your future opponent, the last for the last group phase match. So it means concretely for Paris, that will be Vienna, your next opponent, and for Malta, your next opponent will be the University, United Arab Emirates University. So you can see them debating on Wednesday afternoon. Wednesday morning for your time, and afternoon for Middle East. So yes, many thanks for this match. You will receive the score sheets during the next days from the three judges, and we thank the three judges as well for watching this session. And we keep in touch. So thank you again, all of you. I wish you a great rest of the week, of course. Thank you. Bye-bye.
Thank you. Goodbye.
Thank you very much.
Bye.